Ready? 3, 2, 1, start. This section also is interpreted by the Learned Senior Standing Counsel in the manner that, as the Deputy Commissioner is the person who objects the order of the tribunal and revision was filed by him, the service of the order copy on the Deputy Commissioner is the relevant date to compute the period of limitation. Stop. Section 38 also is common to the SSC as well as the revenue because the sentence reads, any person who objects such an order or the Deputy Commissioner may prefer a petition to the special tribunal indicates that the affected party, whether the SSC or the Deputy Commissioner, may prefer the revision before the tribunal. Stop. Therefore, here also what is applicable to the SSC is applicable to the revenue. Stop. The Learned Senior Standing Counsel refers to Regulation number 23 of Tamil Nadu Sales Tax Appellate Tribunal, which makes it compulsory to the tribunal to communicate the orders to the SSC, the state representative, the assessing authority, the authority from whose order the appeal was preferred, the concerned Deputy Commissioner if he is not such authority, and the Joint Commissioner. Stop. This rule merely lists out the persons to whom the order copy should be communicated. Stop. The SSC as well as the revenue are entitled to get copies of the orders of the tribunal. Stop. In view of this rule, Form 6 of the Sales Tax Rules requires in column number 4 the date of communication of the order of the appellate tribunal. Stop. It does not require the date on which the copy was served on the Deputy Commissioner. Para. The Learned Senior Standing Counsel argues that Regulation number 2X, though defines the state representative as a person appointed by the state government to receive the notices on behalf of the state government and generally to appear, act and plead on their behalf in all the proceedings before the tribunal. There is no obligation in this provision on the part of the state representative to communicate the notice he received to the state, and at the most it can be interpreted that he is bound to receive the notices, but he was not bound to communicate the same to the government authorities. Stop. But this argument of the Learned Senior Standing Counsel is repulsed by the Regulation number 31, which is very specific and emphatic that the notice served on the state representative will be deemed to be sufficient notice to government. This regulation is very much relied upon by the Learned Counsel for the respondent, who contended that this regulation puts an end to the controversy because service of notice on the state representative is sufficient notice to the government under these rules, and therefore the revenue is not entitled to contend that a separate notice is to be served on the Deputy Commissioner. Stop. There is some force in the contentions of the Learned Counsel for the respondent SSC, even though Section 38 of the Act reads that the SSC or the affected person or the Deputy Commissioner may prefer revision before the tribunal. Rule 52 of the Tamil Nadu General Sales Tax Rules 1959. Over.